This lecture is for week 8 for PSY 346 and abnormal psychology, and we're going to talk today about the legal, ethical, and professional issues in abnormal psychology. Now, the important questions to be addressed is who actually treats mental disorders. We're going to talk a little bit about insanity and the competence or incompetence to stand trial. We'll ask the question, can a person be insane but still competent? Incompetent but sane? How easy is it to escape punishment? In terms of pleading insanity, are there dangerous ex-mental patients, and how long does involuntary commitment last? Can people with mental disorders be given treatment against their will? And should psychologists prescribe medication? So these are some of the professional issues associated with our study of abnormal psychology. So to begin with, who actually is able legally to treat mental disorders? And there are many different kinds of professionals that are trained in the assessment and treatment of psychological difficulties. And so these include psychiatrists, clinical psychologists, counseling psychologists, psychiatric nurse practitioners, clinical social workers, and in the state of California and in many other states, licensed marriage and family therapists, as well as licensed professional clinical counselors. And so all these individuals are legally able to, as part of their licensure process, to diagnose mental disorders as well as treat mental disorders. Now, each of these individuals will have a special approach or techniques or ways that they go about doing the treatment and the assessment and diagnosis therein. But all of these professionals do have the ability legally to treat people with psychological or mental disorders. Psychiatrists are generally medical doctors. They have specialized in psychiatry and they have earned the medical degree, so they're MDs. And so that's generally speaking about 4 to 6 years of schooling beyond the bachelor's degree. This kind of psychiatric treatment involves prescription medication of some sort, not usually talk therapy, although there are psychiatrists, then the psychiatrists are able to provide psychotherapy. However, most of them are going to prescribe medications and manage things with the use of medication. What this means is that they often see the most severe mental disorders, the personality disorders, the schizophrenia, the psychosis disorders, things of that nature. They can work in hospital settings as well as oftentimes having their own private practices, medical practices that way. Clinical psychologists have completed doctoral training. They're either PhDs or PsyDs, Doctor of Philosophy or Psychology. Again, this is another 4 to 6 years beyond the bachelor's degree. And so what they would need to do is once they've earned their doctoral degree, they will need to take a year internship usually, or they obtain more hours, and then they would submit for a licensing board at the state level. And so then these individuals would use talking therapy, psychotherapy, to independently diagnose and treat mental disorders. And so they would be in private practice, oftentimes also in university settings, teaching university clinics. Some psychologists do work in hospital settings as well, psych wards, those kinds of things. And so in the United States, they don't prescribe medications. However, there are psychologists that have the privilege in the state of California and some other states, but there's this vacillation even from giving psychologists the ability to prescribe meds to not. And so currently psychologists do not have that authority. However, there is movement toward the ability of psychologists to prescribe medications. Some psychotherapists hold a master's degree, and so that's like 2 to 3 years past the bachelor's degree, and then these can become registered psychological assistants, and then they are under supervision of PhDs or PsyDs. That is, they work underneath a psychologist, which is in psychotherapy terms a protected title. Only a licensed psychologists can treat mental disorders. So the title psychologist is protected, just like marriage and family therapist or licensed professional clinical counselor are protected titles in the state of California, meaning that that you can't use that title unless you've gone through the educational and practice requirements as well as passing the licensing exams. Counseling psychologists also hold doctoral degrees, and they have been licensed. Right, and so here they subsume licensed professional counselor, marriage and family therapist as a counseling psychologist. Again, I'd be careful with that title. They frequently provide assessment counseling services. Not always with less severe disturbances. However, we would tend to refer and do some other things. But again, we're licensed by the state to actually treat people and diagnose people with mental disorders. There are psychiatric nurse practitioners. They've completed training leading to the Master of Science in Nursing, which is 2 to 3 years, but on the bachelor's degree. And then they would have a clinical rotation and nursing boards to diagnose and treat mental disorders. And they may prescribe medication under the periodic supervision of a medical doctor. And so these nurse practitioners would actually have a psychiatric specialty to treat mental disorders. Of course, clinical social workers would have an MSW, Master of Social Work, which would be about 2 years or longer of schooling beyond the bachelor's degree, and then they would complete the other supervised practice requirements leading to the licensed clinical social worker, LCSW credential, and then they would be able to provide therapy to those with mental disorders and other kinds of disturbances, as well as diagnose them. And the focus with the social workers, or if it's a medical specialty, a nurse or a psychiatrist, the emphasis tends to be on medical management of the disorders. Clinical social workers, their specialty would be in doing some of the psychotherapy, but also providing the other kinds of referrals, community support systems needed for individuals struggling with mental disorders to actually get the help that they need. Marriage and family therapists and social and psychologists would provide talk and cure psychotherapy to the clients, and they would refer out things that would traditionally belong to the other disciplines, like the medical components. They would send to psychiatrists, general medical practitioners, as well as clinical social workers for support in that process. What kinds of referrals, social context, meals, rides, housing kinds of issues, all those things would be handled through referrals from marriage and family therapists and licensed clinical social workers and licensed professional clinical counselors. And so, of course, it's very popular. We hear about how people will plead or make a insanity defense, or even question their ability to stand trial. Are they competent? Is this person able to make decisions in a meaningful and rational manner? And so sometimes those with mental disorders find themselves involved in the legal system. It's not uncommon. Psychological and psychiatric evaluations are essential for providing information needed to render a judgment or commitment on commitment, competency, and insanity. And so this process of legal determination is less precise than clinical diagnosis, frequently requiring predictions of what might happen or estimates of the probability of dangerous behavior in future situations. So oftentimes, legally speaking, individuals are wanting to know, is this person dangerous? And are they capable of understanding the ramifications of their decisions? And what would that mean for them? And so some of these issues are competency in terms of standing trial, to manage one's affairs. There's the not guilty by reason of insanity. We can think about civil commitment, the right to treatment, the right not to be treated, and then the institutionalization, which was really discussed well in MAD in America. So competency concerns the individual's ability to handle his or her own legal affairs. And so what this means, in most jurisdictions, people charged with a crime are competent to stand trial if they meet the following requirements. They can understand the nature of the charges, they appreciate the seriousness of those charges and the possible results of a conviction, and they are able to assist their attorney in their own defense. So these are three components to competency. Defendants are assumed to be competent, barring arguments and evidence to the contrary. So the assumption is that this person is competent. If the person is ruled to be incompetent, the legal proceedings may be put on hold while the individual receives treatment to restore competency, trying to get the person able to understand that they are indeed competent and understand, the gravity of their charges and what's been happening against them, which brings questions about things like narcissistic and antisocial personality disorder, where the person doesn't care, has a blatant disregard for the seriousness of their actions. What does that mean for the competency? Are they competent at that point? How important is this understanding, right? For their ability to be competent. And so the hope is that after a period of confinement and treatment, these persons will regain their mental capacities and then be given a fair trial. This procedure has at times led to long-term confinement without the safeguards of a trial. For example, Louis Perioni, the rights of the individuals to be protected for unreasonable detentions based on incompetency have been bolstered. So in this ruling, Jackson versus Indiana, the Supreme Court ruled the length of pretrial confinement should be limited. Assessing competency, of course, is not easy. Some are motivated to exaggerate symptoms or malinger. And so, in one review of 155 criminal defendants referred to neuropsychological evaluation, the rate of probable and definite malingering neurocognitive dysfunction was over 50%. So, not uncommonly, the expert opinions of prosecution evaluators are very different than the expert opinions of defense evaluators. And there are often lots of turf wars and conflict over competency and the competency to stand trial. So a disturbed individual may be incompetent to make treatment choices or to conduct daily affairs. And so then how do you go about getting consent to treatment then, which is a huge first step? Treatment guardian is often appointed when a person with a mental disorder is too disturbed to make informed decisions. Think about it this way. Parents consent to treatment for their children. So the child, because they're under the age of 18, is viewed as incompetent because 18 provides you that adult status in our culture, in California, in the United States, and so therefore, until you're 18, you are incompetent to enter into business arrangements, consent to treatment, things of that nature. And so then the parent needs to consent as the treatment guardian. And so the matter of sanity is a different legal issue than that of competency. Sanity has to do with the person's mental state at the time of the crime, not the trial. This concept is connected to the notion of responsibility over actions and, as a result, over guilt or innocence. Competency and sanity, therefore, involve independent judgment of the mental status at different points in time. So at the very core of this rule is the assumption that individuals bear responsibility for their actions. And so in English law, there's a tradition that if persons are mentally deranged, they have no comprehension of the meaning of their criminal act, then they shouldn't be held legally responsible for that act. So if they were in a psychotic state or something and they didn't really understand or could have empathy on the impact of their actions on another person, then they shouldn't be held responsible for them, which is a very challenging thing, especially for a psychosis disorder, right? So if the person is oriented to reality, but they're perhaps antisocial, can they ever really, comprehend the meaning of their criminal act? And then what would that mean? The McNaughton rule is from England in 1843, knowing right and wrong. So the irresistible impulse rule from Alabama, a pathological driver impulse that individual could not control, had compelled the crime. So the person needs to know right from wrong. Is there a drive or impulse that the individual could not control compelling the crime? So like a crime of passion, so to speak. The Durham rule is an accused person is not criminally responsible if it is shown that the unlawful act was the product of a mental disease or a defect. So this rule proved to be very difficult to apply effectively, as we can even think about. So in our brief cursory overview of abnormal psychology, there are serious questions to some of the diagnostic criteria that we've talked about. Right? This comes out in the reliability of the categories. And so then how would you apply those categories in a legal manner, in a very contested legal battle where there would be defense and prosecutor experts arguing on both sides of this? The American Law Institute issued a more comprehensive standard in 1962, and this standard states that a person is not responsible for criminal conduct if at the time of this conduct, as a result of mental disease or defect, he lacks a substantial capacity either to appreciate the criminality, the wrongfulness of the conduct, or to conform his conduct to the requirements of the law. So there's a appreciate the wrongfulness or the criminality of an act, or, which is an important or, to conform his conduct, even if they don't understand or appreciate the criminality of it. And in this article, the terms mental disease or defect do not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. So antisocial behavior or conduct is automatically ruled out of that. So the Federal Insanity Defense Reform Act described the insanity standard in federal courts, and this act limited the volitional component of conforming conduct to the law and partially returned to the McNaughton standard. A person charged with a criminal offense should be found not guilty by reason of insanity if it is shown that, as a result of mental disease or retardation, he or she was unable to appreciate the wrongfulness of his conduct at the time of the offense. So this goes back then to the antisocial component that was addressed earlier. Sanity examinations must deal with the issues of correct diagnosis and of accurately distinguishing actual from feigned symptoms. And so a U.S. Supreme Court ruling prohibits the execution of mentally retarded defendants. Right? And someone with significantly intellectual deficits could not fake good on an intelligence test, but someone with average or above intelligence could attempt to fake bad. And so we would need to think about what this person is and how they could play this out. It would be hard for someone to fake good on an intelligence test, that is, improve their scores by faking if they were in fact intellectually disabled. Whereas an intelligent person with an average or above average intelligence could fake bad or attempt to at least. So this standardized intelligence tests are not very sensitive to faking or malingering, and their psychological assessments are not specific to intellectual disability. Only one neuropsych test shows adequate specificity for detecting feigned intellectual disability. So that means in the past that the end result has been little different. Has been little difference for defendants whether they were found sane or insane. If sane, they spent many years in prison. If insane, they spent on the average about the same number of years confined to a mental hospital. And so then the confinement would then equate to the prison sentence. The Supreme Court ruled that those acquitted by reason of insanity could be held under indefinite commitment until they proved themselves no longer dangerous. Even this is longer than the sentence that the conviction would have carried. And so here's a list of cases and then the outcomes of those cases through history. And so treatment for the mental disorder is provided if convicted. When treatment is completed, the person is returned to prison to serve out the remainder of the sentence. If the sentence extends past the period of the treatment, release becomes a decision for the justice system, not the mental health system. Right? And so this is a huge issue. Then how do you use how do you use in the legal court system the DSM-5, especially when there's such controversy about it? And so in most situations, the clinical diagnosis, like intellectual disability, schizophrenia, major neurocognitive disorder, gambling disorder, or pedophilic disorder does not imply that an individual with such a condition meets legal criteria for the presence of a mental disorder or a specified legal standard, right? So diagnosis is a mental health issue, not a legal issue, and so they have different standards there. So even when diminished control over one's behavior is a feature of the disorder, having diagnosis in itself does not demonstrate that a particular individual is or was unable to control his or her behavior at a particular time, right from the DSM. A much larger group of mentally disturbed individuals are faced with a different legal procedure, involuntary commitment to treatment facilities. And so the civil commitment under a state's mental health code allows the state to provide protection and treatment to unwilling persons. So what if the person has a neurocognitive disorder? They can't take care of some activities, and so then the state comes in and confines them and civilly commits them to a place. Then what does that look like, and what does that mean for the person's rights to consent to treatment or not to consent to treatment? In most states, this legal ground for civil commitment concerns the degree to which the disordered person is dangerous to self or others by reason of a mental disorder. And so the prediction of future dangerousness is fraught with difficulty, and the results of mistakes can be serious. And so the basic conflict associated with involuntary commitment is between the civil liberties of the individual and the larger concerns of society. So how do we protect itself from how does the society protect itself from dangerous people, and how do we provide help to the mentally incapacitated to understand their own plight? And so this really comes up in suicide cases, for example. So the state law in California is that someone that is suicidal can only be committed 72 hours for their own benefit. So if they are actively suicidal, they have a plan, they can be involuntarily committed for up to 72 hours. After that, then they're assessed, and then if they're not deemed dangerous at that point, then they are released. And so then how does that what is the impact of those things on their civil liberties as well as on the concerns for the larger community? So the prevalence of violence is another one. The prevalence of violence among those with a mental disorder is 5 times higher than those without. So violence is elevated in those with schizophrenia, depression, bipolar disorder, especially alcohol and drug abuse and dependence. And still more than 90% of those with mental disorders are not violent. And so it really is important for mental health professionals to assess for violence, be aware of that, but also balance that with their desires for treatment and those other kinds of issues. So it's a huge component of balancing the individual's rights with with concern on the part of the community. Patients who are voluntarily committed are in a special circumstance. Their liberty has been denied, but they have not been convicted of a crime, and their legal rights remain intact. And so court cases have defined those rights to include the right to treatment, the right to receive that treatment in least restrictive environment that is appropriate, and the right to refuse certain forms of treatment. And a class action suit was brought against the state of Alabama for not providing either mental patients or institutionalized mental retarded individuals with a minimum degree of treatment. And Judge Frank Johnson ruled to deprive any citizen of his or her liberty upon the altruistic theory that the confinement is for humane therapeutic reasons, and then fail to provide adequate treatment violates the very fundamentals of due process. So if people are confined, they must receive treatment. The Protection and Advocacy for Mentally Ill Individuals Act, passed by Congress, established a protection and advocacy system to safeguard the rights of those with serious mental disorders and investigate allegations of abuse. So then there's an important component to protect, right? And so we hear horror stories of individuals being sent to convalescent homes, especially with neurocognitive disorders, and then in those very convalescent homes, then we hear of serious violations where the state will come in and arrest people, remove people, those kinds of things. So there's a need to protect those people, especially when their rights have been taken away from them. Involuntary commitment mandates the state provides treatment to an unwilling person, making the issue of refusal for mental disorders a challenging legal question. No clear and general guidelines that cover the broad range of situations, except that courts have broadly supported emergency treatment, including medication for violent or dangerous patients without their consent. And so it's emergency treatment, it's short-term, and then once the person's stabilized, like so in the case of suicide in California, after about 72 hours, then that person their full rights are returned to them, and they are able to move on and do what they want to do, go back to the regular treatment or do something else. And so then there's this movement toward deinstitutionalization. So psychotropic medications become available in the 50s. It was possible then to control some of the symptoms of psychosis without confinement. And so the 70s, the legal standards concerning the right to treatment in the least restrictive setting take place. And so the population of patients housed inside of state hospitals decreased dramatically, right? And so as we can see here, by 1992, the number had been reduced 77%. So patients in mental hospitals were reduced 77% by 1970. So that's overall, I think, a good thing, as we read in Mad in America with all the just horror stories of how these individuals were treated, and the lack of care and the lack of treatment actually that those individuals underwent. So frequently services for former mental patients are fragmented, and many find themselves homeless without recourse. Although there are many excellent aftercare programs, there are inadequacies of the outpatient mental health treatment in the United States. Homelessness and inappropriate legal incarceration rather, are major problems, and we continually hear in LA County County and other counties in Southern California where individuals are released from state mental health facilities and they're just dumped on the street right at Skid Row, right near where the men's central prison are. They're released as well, and so there's nowhere for people to go, and they still are kind of confused. Maybe they're no longer an immediate threat to themselves, but they also aren't in a state where they can kind of live and work and kind of move on in their lives. And so what do we do with homelessness and inappropriate legal incarceration? And so some ethical issues around this are confidentiality, the privileged communication of the therapeutic relationship, the patient's right to confidentiality, and that means that, this therapy is a privileged communication, but then that needs to be balanced with the duty to warn. So if a psychotherapist has a specific threat, there's a history of violence and an identifiable um, victim, then in the state of California, in most other states, the therapist has a duty to contact the victim and the authorities to prevent that harm from happening. And likewise, in suicide cases, there's a duty for the therapist to prevent that person from killing him or herself. And then, of course, dealing with the idea of prescription medications, right? So, right, we need to, in terms of an ethical obligation on the part of the therapist, right, we don't reveal sensitive information. And so, they feel secure in that notion that mental or physical health are kept in confidence, right? Those are my personal details, and I don't want other people to know about them. And so that means that the therapist client relationship has privilege. There's a privileged form of communication, and so you can't violate that confidentiality without written consent. And so this includes the minor, right? And so there are expectations in terms of the parents and guardians having access to that, what those things mean. If the person has a treatment guardian, then how that plays itself out in terms of who has access to the file. And there are exceptions to those, right? Child abuse, elderly abuse are exceptions where the law says that psychotherapists must break, confidentiality and privilege, as well as self-harm and harm to others. And so, which, usually in the psychotherapist relationship, if the psychotherapist violates confidentiality and privilege, then that psychotherapist would be held legally liable. They would be in trouble. In harm issues, as well as elderly abuse and child abuse, then those violations of confidentiality are expected, and then the therapist would be in trouble if they did not actually breach confidentiality and privilege at that point. And so these rules, of course, vary from state to state, but there is general agreement that the therapists are obligated to make their clients aware of these limits at the onset of therapy. And so there's a duty to warn, and then some things to consider. Should mental health therapists prescribe medication? So the ability to prescribe psychotropic medications has historically centered on medical doctors in psychiatry. However, currently many general practitioners also prescribe psychotropic medication and feel very competent at doing that and managing those things. Prescription practices have spread to include non-psychiatric physicians, and so currently most psychotropic medications are prescribed by general care doctors, and then sometimes it's appalling how easy it is to get those psychotropic medications from non-psychiatric physicians. And so, non-physicians were gaining some limited prescriptive authority. And so, for example, nurses holding the MSN degree, psychiatric nurse practitioners, physician assistants, as long as they were under supervision. And then pharmacists had prescriptive authority in some states as well. And so the APA adopted a policy favoring prescription authority in 1996. Of course, some psychologists do oppose that decision. Some object the training is inadequate. Others believe this path would weaken the integrity of psychological science. Why do we want to approach this from a medical position when we have really good evidence of this talking cure, the psychotherapy, as a treatment for mental disorders? So, nonetheless, psychologists in several states have introduced legislation allowing prescription privileges. Medical psychologists in Louisiana and New Mexico can hold limited prescriptive authority. In 2011, the APA, anticipating increased involvement in remediation management by its membership, issued guidelines for prescriptive practices by psychologists, and so there's a growing movement towards this. So we need careful independent research and empirical validation of the psychological interventions. Of course, that should be the goal of psychological science, and then, it's the psychologist's preference then at that point in terms of adopting medications and their role in this. So this has been an overview of some of the legal and professional issues related to abnormal psychology, and this concludes our lecture for PSY 346, Abnormal Psychology.